case, Kubat and Northern Health, a Turkish interpreter that was working in a hospital filed an adverse action claim against her employer. She had worked as a part-time interpreter for a year and a half, and then at that time she started taking excessive sick and annual leave. She was given a warning for missing work on a few occasions and turning up late. So she produced a medical certificate that said that she needed to return to Turkey to commemorate the second anniversary of her father's death. The employer questioned the medical certificate and its authenticity, but eventually allowed her to take it. When she was due to return to work, she filed a workers' comp claim saying that she was suffering from depression and that she was unfit for work. She took a few months off work and then said that she wanted to come back, so she got sent off to an independent doctor to carry out an examination. The doctor said that she could return to work 1 half day per week, and provided that it was a stress-free environment. The hospital had concerns about that, obviously, because they couldn't guarantee that the environment would be stress-free. They sent her off to the doctor again, and he again confirmed that she couldn't return to work unless it was stress-free. Northern Health couldn't guarantee that it would be stress-free, so they terminated her employment on the basis that she couldn't fulfil the inherent requirements of her position.
So then she subsequently brought an adverse action claim against her employer, and she claimed a number of instances of adverse action, including that she was belittled by her employer. In one case, she was told that she wasn't an asset of the respondent. Also that she was pressured to resign, she wasn't allowed to return to work, and she was issued with a warning when she was suffering depression. Ultimately, the court held that those instances couldn't be considered adverse action because they didn't disadvantage her in her employment at all. The only instance that could be considered adverse action, although ultimately it wasn't found to be, was the termination of her employment. So it's an important distinction, I think, to make. Under the Fair Work Act, only certain things can be considered adverse action.
I think there's also a comment from the judge in relation to the potential that she might have had an action in effect if she'd gone disability discrimination. Because under the DDA, there is an obligation on employers to make reasonable adjustments to the inherent requirements of the position. It's quite different from the adverse action provisions. Whether or not it would have been considered to be reasonable adjustments, it's a situation where reasonable adjustments could have occurred without imposing unjustifiable hardship on the employer is another issue. Obviously, the requirement in any workplace that someone be provided with a completely stress-free environment is almost impossible for anyone to,
I think particularly in this case, I think the judge cited that there was some evidence that one translator had been chased by a patient, and, you know, it's in a medical environment where potentially people are going to be under stress themselves and not necessarily in the right frame of mind to be on their best behaviour.
Look, it is hard to imagine many environments where you could absolutely guarantee no stress. I mean, you look at anyone who's, say, teaching or working in any kind of medical profession, driving on the roads, there's going to be stress. I mean, there's not many work environments where you can be assured that there's no stress. In hospitality, people are often, if you're dealing with human beings, there's a real potential for stress. So whether she would have been successful, I think, is highly questionable, but it does highlight the distinction between the two causes of action.